Order, order.
Legal Aid, Sentencing and Punishment of Offenders Bill.
Before we begin, I have a few preliminary announcements for the committee. Members may, if they wish, Mr. Watts, remove their jackets during committee meetings. Please would all members ensure that mobile phones, pagers and other devices are turned off or are switched to silent mode during committee meetings. I should like to tell all members that, as a general rule, I and my fellow chairs do not intend to call starred amendments which have not been tabled with adequate notice. The required notice period in public bill committees is 3 working days. Therefore, amendments should be tabled by the rise of the House on Monday for consideration on Thursday, and by the rise of the House on Thursday for consideration on a Tuesday. Not everyone is familiar with the process of taking oral evidence in public bill committees, so it might help everyone if I briefly explain how we will proceed. The committee will first be asked to consider the programme motion on the amendment paper. Does anybody not have a copy of the programme motion on the amendment paper? Debate on this is limited to half an hour. An amendment has been tabled by the government to this motion. We will then proceed to a motion to report written evidence, and then a motion to permit the committee to deliberate in private in advance of the oral evidence sessions, which I hope we can take formally. Assuming that the second of these motions has been agreed to, the committee will then move into private session. Once the committee has deliberated, the witnesses and members of the public will be invited back into the room and our oral evidence session will begin. If the committee agrees to the programme motion, the committee will start to hear oral evidence this morning. I now call the Minister to move the programme motion, standing in his name. Mr. Jonathan Ginobili.
Good morning, Mr. Chairman. Thank you for that introduction. And can I say that I and my colleagues are looking forward to serving under your chairmanship over the coming weeks. The dates are set out in the resolution. These equate to 18 sessions over 9 days, including 4 sessions to hear evidence. We think this is adequate time for the consideration of this bill. We have invited a broad range of witnesses and taken some helpful suggestions from the opposition on these. We look forward to hearing from them over the course of the coming days. We propose to take the bill in order, with schedules taken with relevant clauses. We propose that any new clauses and schedules are debated when we get to the end of each part of the bill. And Mr. Chairman, would you like me to also formally move the amendment in table in paragraph 2?
I would, because I think we can take the motion and the amendment all together.
Then I will do so. Thank you.
So we're now open to the floor to debate the programme motion and the amendment. Helen Goodman.
Thank you very much, Mr. Holloway. May I say what a pleasure it is to serve under your chairmanship this morning. We have already made it clear to the government that we do not think the timetable for this bill's committee stage is adequate. We have already made it clear that we think at least 1 extra day is needed for taking evidence. And the fact that the Minister is having to make an amendment to the timetable for evidence because one of the very important witnesses, the Council of Her Majesty's Circuit Judges, clearly can't manage the time. We believe that is evident of the rushed nature which of this bill, which has been followed with this bill. It began by not allowing adequate time between publishing the bill and moving to second reading, and it's continuing now. We've also already made it clear that we think that there should be more days for line-by-line consideration of the bill, extending further into October, and we will be opposing the programme motion this morning.
Mr. Andy Slaughter.
Yes. Thank you, Mr. Oliver. And can I just add my comments? I also look forward to serving under your chairmanship today and throughout the course of the bill through committee. I'll be very brief because clearly there's an irony in taking a long time debating this, which takes time from witnesses. But this is a very important point to make, and it refers to the 2 days of witness evidence. In a way, it's a tribute to the work that the clerks have done in accommodating all or almost all of the 35-odd witnesses who have been put forward by both government and opposition sides here and fitting them in. Because the consequence of that, if there is such a short period of time to deal with each witness, that their evidence becomes not irrelevant, but it becomes so severely curtailed as to not give fair representation of their views. And I just look at 2 examples of that. We have today, I think, 1 hour to hear from the Law Society, the Bar Council, and 2 other very important witnesses in one session. And clearly the Law Society and the Bar Council alone have comments to make, no doubt, about all the different aspects. And this is a Christmas tree bill. This is a bill which has many, many important and differing parts to it. And then I look at Thursday, the 14th of July, where I think in the course of 45 minutes, Shelter Citizens Advice Bureau, the Law Centres Federation, Advice Services Alliance, and R3, which has a particular brief on insolvency. How, Mr. Chairman, how on earth is the committee, with the number of members it has, to be able to adequately question those witnesses in that time? We made a very reasonable request that there should be a 3rd day of evidence, but at least would have given the expanded time to do that, and we haven't been granted that. We also asked for, I think, again, a modest 4 additional days for consideration, clause by clause, of the bill. But let me specifically comment on the evidence today. These oral evidence sessions will not be adequate for the task. It's a subversion of the purpose of those sessions, which is to allow adequate time for these very important witnesses to give evidence. So we will be opposing the programme motion, and on the clear basis that we wish to see 1 additional day's evidence.
Mr. Gummer, then Mr. Llwyd.
Thank you, Mr. Chairman. It is also a pleasure to be serving under your chairmanship for me the first time. I wonder if I could just give a little reassurance to the Honourable Member for Hammersmith. The Justice Committee has looked in great detail at the legal aid proposals given by the government. Considerable detail over many weeks, many thousands of words of evidence. There are some key changes the government has made in response to that consultation, but the great bulk of the proposals is as presented to the Justice Committee, and we investigated at considerable length. And I know the Honourable Gentleman is a keen reader of the official journal from the Justice Committee, but if he were to reacquaint himself with it, he would find ample time and detail of the Law Society, the Bar Council, the FLBA, and a whole series of other organisations which gave evidence in detail, and he would be able to inform himself thereby. And I think maybe the evidence session we have this afternoon is perfectly adequate just to look at those changes which the government has made to the existing proposals.
Mr. Eltham-Llwyd.
Thank you. It's a great pleasure to serve under your chairmanship, Mr. Hollowburn, but adverting to what Mr. Gilmer has just said, I am also a member of the Justice Committee. We don't have a monopoly on wisdom, and I think this process, if it means anything at all, means starting again. We cannot dictate to a standing committee what should be changed in the law, and the whole purpose of today, it seems to me, is to ask experts in the field to give their opinion of a very, very important piece of legislation. How they're going to do it in half an hour each, 3 esteemed bodies shortly, I don't really know. I think it's almost offensive to them. But clearly what I believe is happening here, we are just going through the motions, and that really isn't good enough.
Mr. Watts.
Can I also add my comments that it's a pleasure to serve under your chairmanship, Mr. Hollowburn. Can I say I'm a bit worried about the way the debate's gone, because it seemed from the earlier contribution from Mr. Gummer that he'd come here with a predetermined view about this bill. It's the job of this bill committee to scrutinise the bill line by line and make recommendations and make decisions. It's not, I don't think, Mr. Gummer's job to come to a committee and actually have a predetermined view.
Kate Green.
Likewise, I find it a great pleasure to serve under your chairmanship this morning. I support the comments of all colleagues who've spoken for more time this morning. I merely wanted to add that In my previous experience of sitting on a public bill committee, we also had the opportunity to question the Secretary of State in an evidence session. We are not being offered the opportunity to meet with the Lord Chancellor as a committee. I'm surprised and disappointed to discover that, and I think it's a further gap in our gathering of the evidence.
Mr. Holloman, thank you, and I'm delighted to serve under your chairmanship and look forward to it over and into autumn. Can I say I'm rather surprised from the opposition, certainly, first of all, from someone who was in the previous Parliament to be lectured on programming motions by a government that abused the guillotine to such an extent. I remember sitting in this very room waiting for some evidence from a former director of MI5, which was blocked by the previous government in case she said something that they didn't like. So I think pot and kettle black comes to mind. On the relationship, the subject to the programme motion, I think what is interesting is we're being asked by the opposition to reconsider the programme motion when it seems to be the fact that so far the opposition hasn't tabled a single amendment to the bill itself. So how can we disagree with the programme motion when we don't actually know what the opposition are going to put forward to amend the bill? So far, their ideas, like their policy, are completely blank on this bill. And therefore, they're asking for us to vote against a programme motion because they just don't like the programme motion, but we have deafening silence on any alternatives to the bill.
Okay, the procedure now is we go to decide the amendment on the programme motion, and then we come to decide the programme motion itself. The question is the amendment to the programme motion as on the amendment paper. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question now is the programme motion itself as on the paper as amended. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Aye. Division. Are the whips happy? Proceed. Lock the doors.
Mr. Crispin Blunt.
Aye.
Tom Brake.
Aye.
Mr. Robert Buckland. Aye. Mike Stockhart. Aye. Alex Cunningham.
No.
Mr. Jonathan Ginobili.
Aye.
Yvonne Favarg.
No.
Helen Goodman.
No.
Kate Green. Ben Gummer.
Aye.
Damien Hines.
Aye.
Elfyn Llwyd.
No.
Jonathan Reynolds.
No.
Mr. Andy Slaughter.
No.
Anna Soubry.
Aye.
Elizabeth Truss. Aye. Mr. Ben Wallace.
Aye.
Mr. Dave Watts.
No.
Jeremy Wright.
Aye.
They're voted in that division, ayes 11, noes 8, therefore the ayes have it, the ayes have it. Unlock. We now come to the second motion on the amendment paper, and I call the Minister to move the motion to report written evidence. Mr. Jonathan Ginobili.
Mr. Chairman.
The question is the motion as on the amendment paper. I therefore put the question to the committee. All those in favour of the motion as on the amendment paper say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. Copies of memoranda which the committee receives will be made available in the committee room. I now call the Minister to move the motion about deliberating in private. Mr. Jonathan Ginobili.
Formally, Mr. Chairman.
The question is the motion as on the amendment paper. I therefore put the question to the committee, which is the motion as on the amendment paper. All those as are of that opinion say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. Now, the committee will now meet in private, so I'll have to ask members of the public just to step outside whilst we deliberate, but you'll be most welcome once we go back into public session.